All right. We are hopefully going to have an exciting discussion about the some things that are happening on our public lands with regard to filming. And I'm joined by a few guests today. I've got Todd, Matt, and Ben. And if you guys wouldn't mind just kind of giving just a super quick introduction, who you are, and how people can find you.
Cool. I'm Todd Chamberlain, the Park Junkie. I've got at parkjunkie.com and on YouTube and X at Park Junkie as well. National park videos and exploration of our great outdoors.
I'm Matt McClellan. I've got a YouTube channel, Ozark Overland Adventures. That's been my full-time job for just over 3 years now.
And I'm Ben Burr. I'm the executive director of BlueRibbon Coalition.
Awesome. Thank you, guys. So Ben, what I'm hoping to kind of do here is move through kind of like a Q&A with you and just talk about, there's some things that have been going on that actually been playing out for years with the topic of filming on public lands. And I know that, all of us here, I've had an interest in it. I've written on this topic. I know Todd has been, involved in learning about it and talking about it. And Matt has as well. Mm-hmm. So I'd like to just maybe start with jumping into the history of, what is going on with filming on our public lands. Like, what are the things that maybe people need to know that they're not aware of that have been happening legislatively and in the courts?
Yeah, that's a big question, and I'll narrow it. Filming or photographing our public lands is something that's been happening for centuries now. I think Yellowstone, that was one of the first photographs. It was one of the early places that got photographed as a way to kind of get people to come out and see Yellowstone. And so there's been this activity happening for a long time. As far as the regulations that we're challenging in court, it's really the laws that were passed in the early 90s, like 1993. There was a law that was passed that kind of gave the agencies the authority to regulate commercial filming on public land. If you were to go back in time in 1993, the technology existed to go make a film on public land as the average user, but for you to be able to then distribute and make money off of that, you really had to own a TV studio or broadcasting waves or be part of the film network, like the theaters and things. There wasn't really a great way to commercialize film content in the 90s compared to what we have now. And so this law was written at a time where the only people who were commercializing film content were high-level production studios in Hollywood and people that would make advertising agencies making commercials and TV studios. And so it was really designed to really target that industrial filmmaking activity. And as those technologies and those tools, like social media platforms and other things have evolved, everybody has a full film studio in their pocket and a distribution network and a way to commercialize film content seamlessly and easily. And so we're running into a situation where a law that was written for a specific day and age is just completely obsolete at this point, because everyone who's posting social media content about public lands is technically probably violating this law as it's currently written. And we've run into some instances where agencies have gotten a little more creative and aggressive in how they're enforcing this and against some of our members, and that has invited litigation from our organization. And as you pointed out, we currently have an injunction against this law to where BlueRibbon Coalition and its members are not required to comply with the Public Land Agency's film permitting regulations. There's a lot to unpack there, but that's like the quick overview of where we are. Definitely some court is in the middle of all of that and other things going on, but that's the basic rundown.
Yeah. Okay. Thank you for that. So kind of going back to, what you're talking about in the 90s and laws being developed. So I'm aware of public law 10, is it 106?
We call it a name because it really is just like a generic number, like 107-113 or something.
Okay. It's something like that. Yeah. And that's really kind of what's underlying kind of all this legal churn and things that are going on right now, right? Because that basically instructed the public lands that they had to develop, or the agencies, being the Department of Agriculture or the Department of Interior, that they had to kind of build a framework around the requirements and fees involved for filming on public land for commercial purposes, right? And
Yep.
that's okay.
Yeah, that's what we're talking about.
Yeah. And so, from kind of how I became aware of this topic was back in 2019, there was a case with Gordy Price, which I'm sure is a name you're familiar with. And, my understanding is he was basically criminally charged for filming. I think he was at a national monument. I can't remember exactly, but
Gettysburg National Park.
National park. Okay. I knew it was something in the national park.
It was a national
ecosystem.
battlefield. He was in Yorktown National Battlefield, I think it was.
Okay, national battlefield.
Yeah.
Okay, and he basically countersued the government, saying that he had a First Amendment right to do that. And I know, that case originally, the first trial that happened, and the judge that heard it had ruled that Mr. Price actually did have a First Amendment right to record, and that the laws were really about protecting resources, not about, somebody pulling a phone out of their pocket and recording, or a small electronic device and making money off of it. But the National Park Service / Department of Interior appealed that case, and Mr. Price ended up losing on I think it was a 3-judge panel, and they ruled not in his favor, and I think it was even called out in that case, that there could be fines and up to 6 months in prison, if they sought to take it that far. So is that pretty accurate per your understanding? Is there any kind of details I'm missing out?
Yeah,
as far as
to that. So, I mean, so to your point, I mean, it was the D.C. Circuit Court, which tends to be very friendly to the government, was who ruled against Gordon Price, and I believe it was Gettysburg, and it is a national battlefield, which is managed by the National Park Service. We're just trying to be technical here, and I believe that case also, like especially on the Court of Appeals ruling, they kind of got into like public forums and what counts as a public forum, to where your First Amendment rights apply and where do they not apply. And so that was an issue that was raised, and they basically said that the parks themselves are not public forums, but parks can have public forums within their boundaries, and that's something that we explored a little bit in our challenge. And because like Glen Canyon National Park has public forums in Glen Canyon, and if you go to the public forums, it's like there's a designated area next to the RV sewage dump station where you have freedom of speech. It's kind of absurd, but that's how they look at it. And so public forum is like the National Mall in DC is like a public forum. You have to go through the regulatory process to have like a freedom of speech event there, and so that's an issue that is raised there. And I think the way we look at it is, I mean, in our argument, we don't quite get into that. It really is just we come at it with a different perspective, where we had a user who was out on public lands, named Kyle Brotherson, and he had been recording videos on his GoPro helmet on his dirt bike, putting that on YouTube, and they pretty much triggered that as all commercial content, and they're fining him $1,000 for each video, so an $800,000 fine, threats and demands that he pull down all of his content. And so that,
Ben, what agency was that?
That was the Forest that did that.
That was Forest Service. Okay.
That were with us that were have been regulated by the BLM in a similar capacity, and so we just looked at this and said, look, the government, to the extent it can regulate speech, it needs to do it in the least intrusive way possible, and it has to have a compelling government interest. And I mean, there are boundaries there. And so I think that even though the Price decision kind of went against Price, our lawyers looked at this and found that our case was in the Ninth Circuit Court of Appeals, which tends to have a lot friendlier jurisprudence surrounding First Amendment issues. This is the circuit court where Hollywood has built up its industry. And so there's just a lot of different speech interests out here in the Ninth Circuit that would create a circuit split with that DC Circuit Court and put this on a path to go into the Supreme Court. And so as we looked at this, we're like, this is why it was looked attractive, is that we don't feel like that resolves the questions about, is the government narrowly tailoring these speech restrictions? Does it have a compelling interest in regulating somebody pulling out their cell phone and recording footage of public land? And it's like, and so those are like the big questions. And I think our side of that is to lean very much, come down in favor of the pro free speech camp on that. Is that our rights should trump most government interests here, and whatever.
Yeah, and I was gonna say, and kind of back to that original ruling in the Gordy Price page. I mean, if you're not damaging resources, how are you hurting anyone? Which is, it's been a. I don't have an answer for that, because I agree that it should be about resource damage and not anything else. But
Yeah, there's that, and then there's also like some other issues that were, I think, laid bare in our argument, where the 1993 law did have an exclusion, that if you're part of a news media organization reporting the news, you don't have to get a permit. And so a government's regulatory regime has to be content neutral. In this case, it was not. It was saying, if you're news media content, then you aren't subject to the regulation, and everybody else is. And so they actually were censoring based on content, or regulating based on content. And that's where I think the judge that were before, I mean, if you read his ruling, these are the issues that are really causing him to say this. And where the government was eager to get resolution on the Gordon Price case in the DC Circuit Court, they are not. They're wanting us to. I mean, at this point, the case is currently in abeyance, is what we call it, while we're waiting to see if any of these laws change, because there are proposals to change them. But that means that injunctions in place until that. Like, I think the government's reading the writing on the wall that this could unravel constitutionally.
It's gonna fall. Yeah.
See what happens.
Yeah, and maybe that's a good lead in to kind of, I think, I know for myself and Todd and Matt, I mean, we all kind of share aspects of our lives publicly on social media to some degree. Some of us are a little more well known than others, but there's been a lot of confusion kind of in the creator community since the Gordy Price case, in terms of, when the ruling that ruled against Mr. Price came out, the Park Service was very quick to go and issue new guidance, and made it very clear that you needed a permit, you needed, that you had to follow the rules and kind of all the ins and outs of that, versus other agencies that also fall under the Department of Interior, such as BLM. I think Fish and Wildlife did make it a little more clear, similar to National Park Service did. But, the other agencies didn't necessarily make it as clear as National Park did. And so that led to kind of a lot of confusion about, well, where do I need to get a permit? Where do I not get a permit? And further confusing the issue is, if you actually call these agencies and call particular parks or call field offices, you're going to get different answers depending on who you talk to. Some people will tell you, yes, you need a permit. Some people will tell you don't. I see Matt shaking his head. I know he's experienced this firsthand. You don't get a consistent answer, which just adds to the confusion for people that are in this creator space. And what are they supposed to do? They want to do the right thing, but they don't always get a clear answer. So I kind of like, what is your, I don't know if it's thought or opinion, or, why is that? Why were the agencies, even after that Gordy Price case, so kind of dodgy about it? Was it just ineptness and they don't really understand it, or is there something deeper than that going on?
Yeah, I mean, I think it's just when a government that is our federal government is tasked with a project that really is designed to interfere and regulate our constitutionally protected rights, there really is no path to success for this. It's going down a path that's doomed to fail, in my opinion. It's just, and so that it became arbitrary and capricious, and each office had different rules for how this would work. It does not surprise me in the least that there weren't national standards and guidelines of how to administer this. And that only adds to the problem. And that was something we raised in our case. So BlueRibbon Coalition is content creators. We are named as plaintiffs in our own case here because we're trying to go create informative educational videos about public land and policy changes occurring on these lands. In many cases, operating under environments where we have statutorily defined time limits. We have 30 days to make a public comment and educate our members about an issue. So for us to have, my guess is for those of you who've tried to get these permits, if you were to successfully get the right person on the phone and have them tell you the process, the likelihood that you would get one delivered to you within a 30-day time period is probably next to 0% chance. And so it was abridging our political speech. It was abridging our due process rights and administrative rights to influence government processes. So this is like that's back to my point of like, to create an exclusion for news media, like you've just opened a Pandora's box of like, where does the government's role begin? Where does it end? Who's going to be the decision maker on this?
Yeah.
And it's
And
just wild.
I read a little bit of the decision in the case that you were involved in. And am I right that that the agency that went after the gentleman, I can't remember his name that you shared, but he did. I read in there that he did try to take the media exclusion, but they were
one of them did, I believe.
One of them did. Okay.
BLM group kind of did. They were at an event and they were claiming they were media, and it wasn't. And so how they were defining whether you are the news media or just a YouTube channel, like they don't have good definitions for any of that.
It's arbitrary. Yeah.
And the government, I mean, when we talk about the Chevron deference ruling that happened this summer, and everyone was like, the supporters of the Chevron deference who love these federal agencies, the government simps, they were like, well, how will we have a government if our experts can't weigh in? I'm like, there's no expertise in these agencies to regulate the commercial film industry. They don't have that expertise as land managers. And so for them to be able to create some sort of a regulatory regime to regulate speech content on a social media environment where these platforms are very dynamic in how they operate, how they commercialize is very dynamic. How do you know whether an influencer on Instagram is commercializing or not? I mean, it's not transparent. Like a lot of the influencer deals happen behind the scenes, behind closed doors. So like, to what level, just because I pull out my phone on public land, am I inviting the government to surveil everything I do? And that's why I believe we intended to put very strong guardrails around these rights, and I get super skeptical anytime the government thinks it can successfully navigate those guardrails and start regulating them. It just, and this is one of those laws where, just a case in point, it just obviously hasn't worked. It's a mess. Maybe it can be fixed statutorily, like through these acts with the Film Act and all of these things. But at the end of the day, I feel like the safest place for the government to be is to stay out of this business entirely. I just don't see, like put it this way, like, should I have to go get a permit from the government to determine where I can go to church? Like, I think most people that are religious, if I was to propose that to them, say, well, the government has a compelling interest in where you worship, even though this is a constitutionally protected right. They've come up with a rational scheme on how they can determine and regulate, and you can pay a fee to them in order to go exercise your right to go practice a religion somewhere. Like, most religious Americans would be like, that is the most un-American thing I've ever heard in my life, and that's never happened in our history. It probably never could or should. This First Amendment freedom of speech right should be that firewalled off from government regulation. And if we hear the government saying, well, we think we're going to try, we should all be raising red flags and be like, wait, no. Let's not. And so the fact that they got into trouble with this one, it doesn't surprise me at all. We're finding all the questions of why this was a fraught enterprise to begin with.
Yeah, and making people jump through all these unnecessary hoops and so forth. And Matt, I don't know if you mind sharing. I know you had shared on your channel at one point, an experience you had gone through specific with the Park Service in obtaining a permit, and just kind of all the hoops and things they made you jump through. I don't know if you mind sharing that at all, just kind of the
Yeah,
absurdity that
absolutely.
was behind that. Yeah.
Yeah, and I mean, my take on this, I mean, by the strict definition, I am a commercial filmmaker. I make my living from YouTube videos. Um, but if you look at the wording, especially on like the National Park Service website, you can tell that is very clearly worded for Hollywood productions. Talks
Mhm.
about actors and sets and props and those sort of things, and it makes perfect sense to me that a larger film production absolutely would need a permit to film on public lands because they're going out for longer periods of time. They've got massive sets. They've got all these people that are out there in the land, and like you said, it should be about resource protection. And absolutely get that. But the experience that I had, which was weird, and I know this took place in early 2022, spring of 2022, because I think that price got overturned in October 21 or
Mhm.
something like that.
21. It was 21.
Yeah, that's when that came out with the new
Actually
language.
22. Man, it might have been 22. Sorry, I take that back. I think it might have been 22, but
And maybe
somewhere
it
in
was
that
last year.
neighborhood.
Yeah,
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 it's pretty much
somewhere in there.
range.
yeah.
No,
Me
It
and
was
some
the fall of
friends.
22, yeah.
Okay,
Yeah.
me and some friends were on a trip through Colorado, and through Utah, and we were going to go through Canyonlands on Elephant Hill, which is a very well-known, famous off-road trail through Canyonlands National Park, in the Needles District. And so, knowing what the wording was, I reached out to them, and at that point, it was like, for a certain size production, the permits were free, but you did have to pay $150 application fee, which also, by the way, doesn't make that free. um, and so I was like, you know what? If it costs me $150 to be able to film in Canyonlands, fine, I'll pay that, no problem. But they started saying that all of a sudden my friends that were traveling with me, well, they were actors. And so now there is a fee for each of them. And because it was Canyonlands, they required that I give them a detailed itinerary of where we were going to be, what we were going to be doing. And I'm like, we're just normal people driving Elephant Hill, just like anybody
Doing the
else
same
is.
thing that anybody else would be
Doing the same
doing,
thing
whether they
anybody else
happen to
is.
be filming it or not.
Yeah.
Yeah.
I'm going to be sticking a GoPro out the window on the dash. Most, the most invasive thing that I'm going to be doing is maybe walking 100 yards ahead, setting up a camera on a tripod as we drive by it. That's it. But they said all my friends were actors, and because we were going to be filming in the national park, we basically needed a babysitter, and we had to pay a ranger $50 an hour to escort us through the national park, and that added up real quick because I was like, I don't know if we're going to be there 6 hours. I don't know if we're going to be there 10 hours. I don't know if we're going to take off and go, stop at one of the hikes and do a hike. Like, I don't know what we're doing. We're just going to,
Right.
we're just normal people going through there. And so anyway, it ended up being very cost prohibitive. And so we did not visit Elephant Hill that year.
Yeah.
But,
Okay.
and then I've called other national parks. And the frustrating thing for me is, like you said, Rob, there's zero consistency. From one park to the other. I've called other national parks, like we were talking about before we started recording. I live in Arkansas, and we've got the Buffalo National River. There's some great trails around the Buffalo National River. So I called them. I said, hey, what's your current policy on a YouTuber filming in the national park? I said, we don't care. We don't care. And so I was like, can you give me that in writing, please? And they did. They shot me an email. And other national parks are the same way. Some will be like, yeah, you need a permit. Others are like, you're a YouTuber, we don't care. And then just this year, we were going, my wife and I were going back through Canyonlands and thought we were going to run Elephant Hill again. And so we popped into the visitor's office there in the Needles District and asked them. I was like, hey, I know some things have changed because there is legislation in the works to remedy all this. And I think because of that, a lot of these national parks have backed off because they're like, oh, we don't want the attention probably. And so I asked when I went to the visitor center, hey, YouTuber, we're going to be driving through Elephant Hill. Is there any restrictions on me filming that? And she's like, let me go double check. Let me go ask somebody. And she went to the back and came back and she said, no, you're fine.
Yeah.
So it's I get the desire for commercial filming, but I also see that that's involved in a larger production, not just vloggers traveling through a park doing what everyone else is doing.
And it seems to be very selective enforcement, which is, so you have this whole issue of there's not consistency between the agencies or the parks, the individual units. And then they selectively seem to be enforcing when they do, like there's no rhyme or reason to it. Incredibly frustrating situation. And Ben, I think kind of to your point, you're saying you're not at all surprised because that's kind of how government.
Yeah. And I would say that all of these agencies have all the statutory authority they could ever want to regulate an environmental impact. And it's a law called NEPA that requires analysis of if you're actually going to go impact a landscape to the point that it triggers a NEPA analysis, then there's a process to go through to do that. And a Hollywood film studio production would trigger that. And so it's perfectly fine to require an environmental impact permit of some kind to go if what you're doing is going to create an impact to the environment that wouldn't be caused by other traditional uses, like what the average user is doing. There's like language they have that defines this. And so I think the safest play for the government is to just not have a film permitting scheme at all. They can have environmental mitigation, like the permits to regulate and minimize environmental impacts, and they already do. That exists with events. That could exist with it kind of fall under the special event permit regulations. And Hollywood studio, if you're coming with a certain number of people, you need to get an event permit. And as soon as the cinematographer turns on the camera, government's out of the picture. They're not part of the equation anymore. But if we're talking about numbers of people and what sets are being built and who's having to be closed and excluded out of the area for a period of time, like all of that can be managed through other permitting processes that have nothing to do with the act of filming or photographing public land. And so I don't think the government needs this permitting rule, and that there is a compelling interest to be regulating the speech of Americans. I believe I would like to see the law recognize that public land that's publicly accessible to Americans is a public forum for the purpose of the First Amendment, and that we don't need the government looking over our shoulder on what we're doing on public land when it comes to exercising that right. And then to regulate a group activity, which would be a Hollywood film production, they have all kinds of rules and laws they can draw from to regulate that. They don't even need this film permitting regime to do it. And to Matt's point, that you'd get a completely diametrical answer from the same park running the same trail. It just is inoperable, this law, and there isn't a way to apply it uniformly. The sheer volume of Americans that are already technically violating this law, posting on social media, is like it's unenforceable to uniformly enforce it.
Yeah, that was a very eye-opening. When I mentioned I wrote on this a couple years ago for Expedition Portal, I guess it was this last year, and I had a lot of conversations with these agencies and leadership at the agencies and lead permitting administrators, and I had one of these agencies in particular. Well, it was not National Park; it was another one. I had like a 2-hour conversation with their lead permit administrator, and he was talking to me about this issue of just social media in general, and basically implying that whether or not I was making money off of something I posted on Instagram, for example, that the platform was making money, and per the letter of the law, that still required a permit. And that just blew me away to hear that somebody would even be thinking about it at that level. Which, I found a little hard looking at the letter of the law to maybe argue with that. but it's
That's a
absurd.
generous interpretation. And I think that, I mean, the Forest Service agency that was regulating Kyle Brotherson told him, even if he's not technically physically standing on federal public land, but you have like a mountain that is federal public land in the background, he would still need the permit. I was just like, could you get that in writing? Because there's no way. Like, I have like Zion National Park out in my backyard. And so you're telling me I can't film on my private property that I own because there's this national park I view?
It's absurd.
No, that is not America.
Maybe this is a good segue into, I mean, obviously there's a lot of problems, right? There's issues that need to be fixed. And, there are some legislative changes in the works. And Todd, I know you want to say something.
I do. Just a couple of points real quick. First of all, that Gordy Price case was unfortunately not to our benefit because Gordy Price was a film production. He did have people. He had an entire set and numerous people, I think 8 to 10 people on that. So it's kind of unfortunate that his case was the one that went forward, and then the Park Service subsequently used that decision to include YouTubers and social media influencers under that umbrella because he was a film producer, and it's unfortunate. I'm not in any way advocating the government's position here that he should have had a permit, but he wasn't like Star Wars or something. But he did have a production crew with him, so the argument that he could have damaged resources or something theoretically could have been made. And I've been to that place where he actually filmed that. It was Colonial National Historic Park in Yorktown, Virginia. And there's really nothing there that you're going to damage. I mean, it's basically fields, you know what I mean? So that argument really is weak, and they went for him for a reason to actually, I think they were looking to kind of enclose everything in a little more tight of a restriction. And it's just unfortunate that YouTubers fell into that. And if you look at how they did it, the Park Service subsequently kind of wrote YouTubers into that. And just another point that I wanted to bring up to what Matt was saying earlier about the requirements that they have you filling out in the application for these permits. If you look into the permit fees, because I've heard a lot of people say, well, the park needs to generate revenue from this activity of people, making monetization off of public resources. One of the problems with that is if you look into that and you're like, okay, well, if a Hollywood studio did come in to Zion National Park and they wanted to actually create some form of revenue from the filming permits on these public lands, then they could do so, and they theoretically would be justified in doing so for a large scale film production crew. But if you look at the rates that they have, and I actually have them pulled up right now online, the commercial filming permit rates for 1 to 2 people, $0 a day once you get the permit, which of course you're paying for that permit. 1 to 10 people, so you could have 10 people, that's $150 a day. But then if we skip over that and go down to the 50 people or more, it's only $750 a day.
So
now that is nothing.
Yeah.
That's nothing for a major film production crew. So and actually, it's if the Park Service really wanted to be making money from this, they would be charging much more than $750 a day for a major film production crew. And that kind of just destroys the part of that argument in my mind. And I'm really kind of questioning myself, like what purpose, what's the ultimate motive for the Park Service behind that? And that probably gets into where you're segueing to next, is like, why is this happening, and what can be done to sort of mitigate that on public land?
Yeah, and I think just one thing I'd like to kind of just make clear that, we talk about the national park because I think they've been the most high profile about it. But this case was really with the Department of Interior, right, which oversees BLM, Fish and Wildlife, and National Park. And the public law that it's based on is actually the Department of Agriculture as well as Department of Interior, and which has very similar laws, or their rules, rather, the rulemaking process. So again, I feel like it's an important distinction to make because it's much bigger than I think a lot of people realize in terms of kind of all the agencies that are involved. It's all of our public lands, honestly, right?
So, well, and if I might bring up a point to that, if theoretically all of the people who were producing films on public land that they are getting monetization from on a social media channel, if all of those people were to suddenly say, "Oh my, I'm in violation of federal law. I need to go get a permit to do this," there's no possible way that the Park
Oh, that they
Service,
could
the
do it. Yeah.
Department of Interior, the
That
BLM, the Forest Service,
yes.
there's no possible way they could ever begin to even deal with that.
Yeah.
There's just not possible. They already can't deal with the crowds in the parks today, and yet they're going to somehow manage who's filming on public lands when you've got tens of thousands of people literally
Yeah.
pushing
And
record
that's what it comes
every
down to, the
day.
whole like selective enforcement and all the agitating
Absolutely.
stuff and the different answers. Yeah.
It's kind of like a cleaver over your head all the time, you know. It's like if you say
Yeah.
something we don't like, well, we could come after you, you know. And I think that
Yeah.
gets into what they call what's the effect, the like the silencing effect. I forget the exact term.
Chilling.
That could be. I'm sorry.
Oh, the chilling effect of.
Yeah, the chilling effect, exactly,
Yeah.
right. And that might be some motive for it, and I'm not sure. And maybe they would want to sort of create a way that less people would be speaking out in national parks about whatever the case may be, whatever they wanted to sort of regulate. I'm not sure what means they would, or what real philosophical idea they have behind restricting access to filming and First Amendment rights on public lands. But
Yeah.
it could be that they just want to create a chilling effect, like it looks like we have on many of our platforms in society as a whole today. But
Yeah.
Um. Yeah. So I guess kind of getting back into the possible legislative fixes, right? Because none of these are laws, but they're back in 2021, there was something called the Film Act that was introduced. Todd and I know a lot about this. We were kind of arm in arm bugging the Senate E&R committee and talking to the attorneys, he and I both, about the language that was in that bill and some issues we saw with it. And they did actually clean some of it up, which was nice to see. And Todd, I know he was even ended up, I think, down there in their office meeting face to face with them about that. So the Film Act, basically, let me just give this a kind of a high level of what it's doing, but it is attempting to change the permitting process so that a person using minimal filming equipment and a particular number of people, which I think they have set to less than 6, which would be 5, does not require a permit to film. Now, if you have more than 5, up to 8, I believe it is, there's a de minimis permit, they call, which is supposed to be some new process that doesn't currently exist that would make it easy to get a permit. I'm picturing this is something like I go online, I fill out a form, and it gives me a permit instantly. And I believe that's also supposed to be at no charge. And then anything above that would be, the old rules apply. But they did not carve out any exclusions for the wilderness areas. And Todd, I know this has been a big one for you. Maybe you can kind of speak to that a little bit and what's going on there, because I know you had some specific discussions around that. So why wilderness areas, if this became law? And by the way, I should mention, let me just look at my notes here, make sure I get this right. HR 6492 is currently sitting with the Senate, which has passed the House. And then there's S 873, which is also sitting with the Senate and has not been voted on as of yet. So those are the 2 bills that contain the Film Act. If either of those were to pass and become into law, what we just spoke of would become the case, but it excludes wilderness areas.
yeah, part of the problem here is that these bills are like we see with many other aspects of our federal government and the bureaucracy. It's not just the Film Act that they're working on. Like with I think it was the Outdoor Recreation Act of 2023 was what I was in D.C. to discuss with a few of the attorneys from the Senate Energy and Natural Resources Committee. And unfortunately, there's so much wrapped into these bills. It's not just like, oh, it's about filming. No, it's about commercial guiding. It's about like the extension of the Federal Lands Recreation Enhancement Act. There's just so much that they bundle into these 900-page bills. And that's why they never move beyond committee, is because, I mean, that the Outdoor Recreation Act of 2023 never went beyond committee in the Senate, and now we have this Explore Act sitting there, and it's been sitting there for like 6 or 7 months now, and I'm doubtful that anything ever happens with that either, because again, it's one of these giant pork omnibus bills that will require everybody talk. I mean, there's just no real consensus on that because there's so much packed into these things. But that's a major problem. But when I talked to those guys, they were really receptive to my ideas and to my point of view. However, to make things happen, there's so many major hurdles. And as you were saying, Rob, the fact that the Film Act, I believe they've got some carve outs for filming in the parks being protected through the First Amendment, but they do exclude, at least at that time, they were excluding wilderness areas. And I'm not sure exactly what the legislation is at this point that they have. But if you're giving permission to film in national parks or public lands, period, unfortunately with national parks, and I speak about national parks mainly because most of my filming has been done in national parks. Most national parks are 90% wilderness. So if you wanted to go out and film your expedition through the backcountry of any number of national parks, I mean, here in Zion, I mean, you couldn't go into this area behind me right here. That's all wilderness areas. So theoretically, despite the fact that you're just carrying a tripod with your phone on it through that wilderness area, or even if you just have your phone in your hand like this right here, that would still maintain the necessity of that would still remain illegal because you're in a wilderness area, even though you're doing nothing to damage any of the resources that are surrounding anything more than anyone who would be hiking, even if they just had nothing more than a backpack. So it is a concern, and I do believe that it's more difficult to get anyone to really listen to the concerns of walking into wilderness areas because we, as the American people, have this sort of romantic idea of what these wilderness areas are. And I think we all would probably in this discussion agree that the wilderness areas are important. It is important to maintain a wilderness environment, both for the native wildlife, the flora, fauna, and for the human spirit. But I think that this is becoming an issue that is sort of outgrowing itself, in that it becomes or sort of it sort of damages itself, because you've got areas where and this is sort of digressing a bit, but you get into these areas where we can't really expand trails right now. And this goes to talk about kind of the overcrowding of national parks, for example. Everybody's being stuffed into these little corridors, and there's, with a swelling number of visitors to national park areas, such as Zion, for example, in the main Zion Canyon, the Park Service can't really send them out into these other areas to dissipate, to sort of spread out the impact of the crowd. And that's unfortunate, because the Wilderness Act really restricts the ability to send people into those areas. You couldn't build a trail, for example, into that. So the Wilderness Act is a great idea. I think that part of it's going to be very difficult looking forward to see how we can negotiate this as we move forward into a area of time when more and more people are exploring the outdoors. But I think the Wilderness Act overall is slightly problematic here, in that it's really restricting the ability of the parks to expand their horizons with where they want people to go. And we've got to be careful with that, of course. But as far as the filming restrictions are concerned, it definitely is problematic, because most of the national park, for example, is going to be constituted of a wilderness area for sure.
Yeah.
Yeah, so to some of those points, the Film Act, the Explore Act, I've talked to some of my contacts in the Senate, and it's like, I talk to folks in the House, and like, we don't think they're going to pass it. You talk to people in the Senate, they think, yeah, we think this will get done in the lame duck session that will come after the election. I still think that's a pretty tall order. They'd have to attach it to, like, there's a defense bill they've got to pass, and I think they've tried, and that's already failed. So it would be a legislative miracle if they do it, but sometimes it is these public land ones that do float through and get stuffed into an omnibus bill. So I'm looking at this as, it's like maybe a 50-50 chance. I do believe because of this injunction, I bet the agencies are actually lobbying for it because they want this to go away. If
they want to fix it too, yeah.
We would probably have to move out of abeyance and go back into aggressive litigation on this, and they could have their whole program overturned by either the Ninth Circuit or the Supreme Court. And so it's, at least with the Film Act portion of this, there's at least going to be some effort to try to get that passed, coming from a lot of different corners. To your description of it, Rob, I mean, I've followed it as well, the different iterations of it. It's better than the current situation, but it still starts from the premise that there is a compelling government interest to be regulating this speech, and that a group size limitation isn't an arbitrary application of this, which it is. I mean, my family, I have 6 people in my family, so I can't go take a family video in Zion without a permit.
Good point. Yeah, very good point. Yeah.
And then to Todd's point about the wilderness, I mean, I've read the Bill of Rights, and I don't read in the First Amendment that my freedom of speech exists until I step foot into a wilderness area.
Yeah.
And Congress shall make no law to abridge that. Like, I don't see why the wilderness even matters. I don't forfeit my rights because Congress created a wilderness area. Sorry, I don't.
Yeah.
I can go pray in the wilderness, and Congress has no ability to come in and tell me I can't exercise my First Amendment right there, and that I'm somehow impairing the wilderness value when I do that. And that's how we should be. Our Bill of Right protected rights trump the Wilderness Act. Sorry, it is subordinate. It is, the Constitution is superior here. And I don't care how much you love wilderness, I do not think it should. That exclusion for wilderness areas feels very unconstitutional to me.
Yeah.
But it would be one thing. It would be one thing if we had a film production crew going into a wilderness area, right? I mean, that would be different if you had Star Wars being filmed in a wilderness area. But that's just the unfortunate.
We'll never
Well,
get
yeah. I mean, you could see an argument being formed there really easily, right? But at the same time, it's just once again, just to reiterate, it's unfortunate that the phone filming community is included with film production crews, because it's obviously totally separate.
What the impact is. Like the Wilderness Act is that it has to be untrammeled by man, and the person who wrote that didn't look up what the word untrammeled means, but let's assume it means what they think it means, which is untrampled. Which is not what untrammeled means if you were to go look in the dictionary, by the way. But pulling out your phone doesn't cause an impact to like the processing of electrons through silicon inside of an aluminum box does not do a thing to the actual natural environment in a wilderness. So it is absolutely absurd that would be a regulated activity.
Agreed.
Well, so there is at least some good news that we've touched on a little bit here as we had this conversation, and that is, at least at this point in time, Ben, you guys have secured an injunction that any Blue Ribbon Coalition members are not required to get permits filming on federal land. And that is correct. Okay. And my understanding is there was also no exclusion for wilderness areas. So the ruling doesn't speak to it either way, is my understanding. I don't know if you could.
It really just was like, these agencies can't enforce this rule against Blue Ribbon Coalition members while the injunction is in effect.
Yeah. So I think, yeah, I mean, I can't kind of, with that knowledge, I've struggled, because this happened actually earlier this summer. It was like June or July or something. Is that when the injunction was issued? Somewhere around that time frame.
Yeah, I want to say it was June-ish, but maybe it was July.
Okay. Yeah, and like why people weren't out there screaming from the rooftops that this had happened, because I think this is huge news in the creator community. And I mean, I think anybody who is in this community should be joining the Blue Ribbon Coalition. This is just my opinion. But support the organization that is out here fighting for these things and helping to actually tangibly make them better. So, I would just encourage anybody who hears this, especially if you're a creator, go support the Blue Ribbon Coalition. And Ben, go ahead.
$50 a month or $50 a year. It's not a lot to become a member, but we do invest a lot of time and effort into administering a membership program so that we gain legal standing from our members. That's like why our lawyers liked this case, was because one of our members had actually been injured by this. And so it's like a two-way street. Like, our members are what give us the positioning to fight these legal fights. And then once we secure legal victories, that in a lot of cases you'd see like a whole program struck down. But we had some instances where you had like these circuit court judges in Texas and elsewhere. There were some who were just like shooting down the whole immigration program. Like, and the Supreme Court was kind of like, look, you guys have to be a little more precise in how you're administering injunctions and things on these federal programs and how you're enjoining them. And so, had this happened a year ago, I wouldn't have been surprised to see them just strike down the program. Now they're kind of like, we'll give a limited injunction to BRC and its members while we work out these issues in court. And so it's one thing's clear, like the courts are certainly evolving around these issues. There is value there. I mean, we kind of agreed that we wouldn't go out and with a lot of fanfare and aggressiveness try to recruit members around this. And so that's why we, to your point, is like I wasn't going to just go blast this from the rooftops, but I am.
Yeah.
I can't tell the truth. What happened? I mean,
but I think as someone not affiliated directly with the Blue Ribbon Coalition, I mean, I'm a member, but it's okay for me to go out and do that, right?
Yeah, I mean, people say no, but I did, and it works. When I was going to Glen Canyon, and I mentioned I'd met with the superintendent before, and I told her like, "Hey, I'm gonna probably make some videos out there," and she's like, "Oh, you do need a permit for that," and I was like, "Actually, I don't," and she's like, "Oh yeah, you don't," and it's, and so it's I wouldn't like just be very like I think I want our members to just recognize the gravity of the situation. We're trying to fight for these very important constitutional rights. As a member of Blue Ribbon Coalition, you are not required to get these film permits while we and the government and the Congress and everyone who's working on this issue sort it out and hopefully come up with a better system than the one that's currently being challenged.
Yeah, makes a lot of sense.
Ben, well, I'm just curious, as a full-time content creator, and I think that I am a member of the BRC. I know I gave last year to it. Mm-hmm. How do I make sure that I am an active member of the BRC?
Great question. Thanks,
that's a good question. So you could definitely just like go to our website, BlueRibbonCoalition.org, click on the contact link. That form should send to our administrative director, and you could ask him to say, "Hey, I want to check on the status of my membership," and he'd be able to look you up in our database pretty quick and get back to you. Probably through email would be the preferred outcome. Or you could just go to brc@sharetrails.org. Kind of goes to our office email. That's probably the best way, but you are going to have to get in touch with our administrative director who manages the membership program.
Okay. Definitely will do that.
Yeah, good question, Matt. That's a good one. I'm sure a lot of people would like to know, and maybe they're not sure if they're a member or not. Maybe they gave at one point, they don't know. But
yeah, and so we do have like this monthly one. So if you're like getting a drawdown every month, like $5 a month, and as long as you see that on your card, then you are an active member. The other ones are all annual, and there's like a $50 level or $25 level, and then we have a lifetime membership that's $600, I think, and that would kind of cover you forever. But so there's options of how to manage that. But if you have a question about it, I'd just check in with our team.
Ben, do those automatically renew? I know I signed up like a month ago, so it'd be a year or so more. But like, does that renew automatically?
Usually, yes. Like I think there's a box you can check to like do an annual recurring version of that, and the monthly one obviously is checked to be monthly unless you. And so the systems are designed to kind of incent like to give you the option to do that, but we also don't want people like accidentally opting into recurring donations they didn't intend, so we have to do refunds. So we've usually set the default on that you have to trigger that. We don't automatically trigger it.
Good stuff. Well, I think we're getting close to our time here. I appreciate all of you guys, coming on and having this discussion, and it's an important one. Ben, I'd like to just kind of give you the final word here. I mean, we have maybe 30 seconds or so, a minute. Do you mind just kind of giving us? I know Blue Ribbon Coalition is involved in a lot of things beyond this. Can you kind of give us just the high level, maybe few important things you guys are involved with, and just your bigger level, mission that you're on, and kind of a quick.
So, summary. I mean, we are in the 10th Circuit Court of Appeals right now, challenging national monument, like the Abuse of the Antiquities Act and how national monuments get designated. We are challenging hundreds of miles of closures around the Moab area. Those are our other big lawsuits right now. But we get involved in hundreds of actions every year, from Arkansas to Utah to Rob, I forget where you are.
I'm in Utah, also
Yeah,
Utah.
it's like
Matt's the odd man out here.
federal public land we are generally involved in because we react to anything the federal agencies do. And so the best way, I mean, if you're a member, you become subscribed to our weekly newsletter that comes out every Saturday, and we educate people on all the issues we're working on every week. There's always something new, and it's a good way to keep up to speed and be a more active and engaged and educated user of our public land. You don't have to always agree with everything we do. We're all, our default position is always to kind of support as much public access on public land as we possibly can, because we think there's so many benefits that come from that access and the recreation that we experience there. But we also support responsible use. We support reasonable management. We advocate for the land managers to manage to accommodate recreation, but not completely ignore the impacts. And so but the fights get very polarized. So you might hear a whole lot of different things about what people think we believe, but generally we just want the land open for responsible Americans to go and enjoy as freely as makes sense, especially when it comes to our constitutional rights, as freely as we possibly can. And so that's my closing pitch. I know there's a lot we're involved in, but those are some of the highlights.
Good stuff. Thank you guys so much, and I'll look forward to hopefully coming back and discussing this again with some updates and some better news. Thanks very much.
All right,
Thanks, Rob, for having us.
Cool. Thank you.